All right, the court is calling 2019 CR 5167, State of Texas versus Albert Lavine or Lavine. Mr. Lavine,
Yes, Your Honor.
did you understand you're charged with injury to a child as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, it could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, there's to be a $1,000 fine with $500 of it probated. State recommends deferred adjudication. There's to be no harmful or injurious contact with Madeline, Cruz, Danielle, Cortez, the BIPP course.
The case begins with the court calling State of Texas versus Albert Lavine. Right away, the charges are serious: injury to a child, a felony offense with potential jail time, and a heavy fine. The judge carefully lays out the punishment range: up to 2 years in state jail and $10,000 in fines. Notice how Lavine quietly responds, "Yes, Your Honor," to each question. But here's the twist. Despite such heavy charges, the state is recommending deferred adjudication. What do you think? Should someone accused of harming a child get a second chance like this?
TAP evaluation, plus following all recommendations, parenting classes, 120 hours community service restitution, and there's an affirmative finding of family violence. Did you understand that the court is in charge of conditions of probation?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as a primary custodial parent?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 5 years. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense is charged in indictment. How do you plead? Guilty, not guilty, or no contest?
I'm guilty.
Are we proceeding with sentencing?
We would waive the PSI, Judge.
Anything you wish to say on behalf of your client?
Only that this did happen back in 2018, and he has kept himself out of trouble. He is residing currently in a program through Haven for Hope at One Haven, or I think the apartment complex overseen by them with his family. And so the state was nice enough to agree to probate half the fine as to see if the court could consider any kind of accommodation possible to help him.
Now, the plea bargain terms are read. They include parenting classes, 120 hours of community service, and even a restriction that Lavine cannot own weapons due to a family violence finding. The judge asks if he understands, and again, he simply answers, "Yes, Your Honor." But behind those short words is a life-changing reality. His ability to parent, work, and even live freely is on the line. Do you think Lavine truly understands the weight of these conditions, or is he just trying to get through the hearing?
Succeed, not worrying so much on the financial end and focusing more on reporting in the classes. And aside from that, we would just ask the court to follow the plea bargain.
All right, Mr. Lavine, is CPS involved?
No, ma'am.
Judge, I asked them earlier, they were involved, but it was closed.
All right, did you do any classes for them to close this case, Mr. Lavine?
I attended 2 of them, 2 parenting classes, and then I never attended the rest.
So you didn't finish parenting classes?
No, ma'am.
So basically what ended up happening is the mother of the child, is she with the mother?
Yes.
So what happened is the mother of the child stepped up to do whatever classes that were required of her, and you did not. So the
Yes,
case
ma'am.
was closed not due to your actions. It was closed due to the mother's action or the fact that they considered that the danger was alleviated by you not being around.
This is where the judge gets sharp. She asks about CPS involvement, and Lavine admits he didn't finish his parenting classes. Instead, it was the child's mother who stepped up to meet the court's requirements. The judge calls it out directly, saying the case was closed not because of him, but because the mother took responsibility. That's a harsh truth. The system gave him chances, but he failed to follow through. How do you feel about the judge pointing out his lack of effort so openly?
Ground.
Yes,
So
Your
when's
Honor.
the last time you saw your child?
Maybe like 2 years ago, 3.
All right. So why are we doing no harmful or injurious contact? The child doesn't even know him anymore.
Judge, a lot of the notes on this case are from a long time ago. So at that point in time, he was involved.
All right. Are you employed?
No, ma'am, not at the moment. I'm Haven for Hope is helping me get my ID and social because I have my birth certificate.
All right. And is this the only child you have?
Yeah, I have one other child with the same girl, but I haven't seen her.
So this isn't the only child you have. How many children do you have in this world?
2.
All right. This is what the court is going to do. $1,000 fine, probated, 5 years deferred adjudication, the BIPP course, affirmative finding of family violence, parenting.
Then comes an emotional blow. Lavine admits he hasn't seen his child in 2 or 3 years. The judge questions why a no-contact order is even necessary if the child doesn't even know him anymore. This moment is heartbreaking. Imagine being in that courtroom, hearing a father acknowledge years of absence. Is this justice or is it tragedy?
Classes. There's to be no contact with Madeline Cruz and Danielle Cortez. I just have a question, Mr. Lavine. How is it that you're saying that I'm assuming one of these persons, Daniela Cortez, is your child, is that correct?
No, that's my baby mama.
Okay, Madeline Cruz is your child?
Yes, ma'am.
Okay, and can we say the mother of my child? Why is it that Madeline Cruz's last name is Cruz, Danielle's last name is Cortez, and yours is Lavine?
I have that's the name she picked for her.
What, people just going around giving people last names that are not even related to anyone?
That's her mom's last name.
All right, well, that is not for me to understand. That's something for your attorney to understand why on a child's birth certificate, it doesn't have the mother of the child's maiden name. It doesn't have your last name, but it has the grandmother's last name. All right, so there's to be no contact with Madeline Cruz or Danielle Cortez.
The tension rises as the judge digs into family details. She notices the child's last name is different, Cruz, not Lavine. Her frustration shows when she asks why the child carries the grandmother's last name instead of the father's. This small detail exposes a larger truth. A broken family, fractured trust, and unanswered questions about responsibility. Do you think the judge was right to press him so hard on the last name issue, or was it unnecessary?
No unsupervised contact with minors. Mr. Lavine, as soon as you do some parenting classes, of course, the court will reconsider the no contact order, but for now, your anger issues need to be alleviated, or you need to know how to control them, because little children don't have a lot of impulse control. And sometimes people tell me they will get on your nerves. And when they do, you have to know how to handle that and not handle that in anger. You understand?
Yes, ma'am.
All right, so there's to be no unsupervised contact with minors, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. CPS compliance, if any. 120 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. I'm not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. You must complete parenting classes, and once you complete parenting classes, The remainder of your community service hours will be waived. There's to be regular reporting by Zoom or in person. Field visits, one time per month. If you're drug tested today, what are the results going to be, Mr. Lavine?
I should be able to pass it. I've been at Haven for 2 weeks, so
When's the last time you used?
maybe like 3 months ago.
All right, we'll do regular UAs. Rebecca, is there anything else that he needs?
No, ma'am.
Mr. Lavine, is there anything else that you need from the court?
No, ma'am.
All right, that will close the docket. Mr. Lavine or Lavine, good luck to you. Get a control of your anger.
Next, the judge sets strict conditions. No unsupervised contact with minors. Proof of employment within 45 days. No jobs around children, community service, drug testing, and ongoing probation supervision. She reminds him bluntly, children test, patience, and a parent must control anger. This is one of those moments where the courtroom feels less like punishment and more like a desperate attempt to teach a life lesson.
Yes, ma'am.
And are you Mr. Albert Lavine or is it Lavine?
15.
Lavine?
Yes, ma'am.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? I'm going to need you to speak up so the
Yes,
court
ma'am.
will prepare. All right. Are you the same Albert Lavine who was placed on deferred adjudication in 2019 CR 5167 for the offense of injury to a child bodily injury reckless on April 25th, 2022 for a period of 5 years? Is that you?
No, ma'am.
You're not that person?
Yes, I am, but I'm not the same person now. But yes.
Are you the same person who's on deferred adjudication
Yes.
for the offense of injury to a child bodily injury reckless? And you were placed on probation on April 25th, 2022. Is that you? For a period of 5 years, is that you?
Yes, ma'am.
All right, State, you may proceed.
Yes, Your Honor, we are proceeding a violation condition number 4 in the state's motion to supplement. And that is going to be in Bear County, Texas.
Just one second. Did you review the supplemental motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
All right, does anyone have a supplemental for the court? Thank you. Thank you. All right, State, you may proceed.
Violation of condition number 4 in Bear County, Texas. The defendant, Albert Lavine, did then and there fail to report to the supervision officer as directed for the months of September, October, November, and December in 2022 in violation of condition number 4.
How do you plead to that? True or not true?
True.
And the state will waive the remaining violations.
Any objections to the state's waivers?
No objection.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty?
Then comes the shocking turn. The judge confirms, this is the same Albert Lavine already on deferred adjudication from 2019 for the exact same charge, injury to a child. Suddenly, the case shifts from second chances to repeated failures. When asked if he violated probation by not reporting for months, Lavine admits, true. Just like that, all the leniency he once had begins to crumble. Would you have admitted guilt here or tried to fight it?
Sentence you to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor. That agreement is for 12 months in the state jail facility.
That is the agreement.
All right, has he done anything on probation?
Your Honor, our information is that he has absconded since 2022.
All right.
My understanding that Mr. Lavine had experienced homelessness during some of that time. He's speaking with his mother-in-law who's in the courtroom. He also has some mental health issues and learning disabilities that he's overcome that has made it difficult for him to find probation. But he hasn't been arrested in that time and he takes responsibility. He's ready to put this plan.
So has he done anything on probation?
I don't. He's done very much in probation.
So he's done nothing.
That's correct.
All right, this is what the court is going to do. The court is going to find violation of condition number 4 true. The court is going to find you guilty.
You're right.
The court is going to revoke. The court is going to sentence you to 20.
The state argues he's done nothing on probation. His defense points to homelessness and mental health struggles, but the judge isn't swayed. She makes it clear, probation means effort, and Lavine hasn't made any. The weight of accountability falls heavy in the room. Should the court show more compassion for his struggles, or is the judge right to focus only on results?
23 months in the state jail facility, give you credit for any time served. There's to be no unsupervised contact with minors. And there's an affirmative finding of family violence. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication. Because this is a felony conviction and also a finding of family not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. And counsel, I'll retain jurisdiction.
Okay, thank you.
All right, thank you. Yes,
May I please tell my family bye?
no. Well, let me tell you, I say no. I'm stepping outside of my lane. The deputies are in charge of security. I'm not, so you need to ask that question to them. Deputy Laura, he wants to say goodbye to his family. She said no.
Finally, the hammer drops. The judge revokes his probation and sentences Lavine to 23 months in state jail, with credit for time served. No unsupervised contact with minors, no weapons, and a formal finding of family violence. When Lavine asks for a moment with his family, the judge declines, saying security, not sympathy, decides. It's a cold but powerful ending. A father stripped of freedom, cut off from his family, and paying the price for years of failed chances. This case highlights a painful truth. When children are involved, the court demands accountability. Despite multiple opportunities, Albert Lavine failed to follow through with probation, parenting classes, and reporting requirements. In the end, his excuses didn't outweigh his actions, or lack of them. The judge's ruling sends a clear message. Protecting children comes first, and repeated failure has consequences.